Chief Judge presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I've been introduced to you. The other members of the panel to my right, we've got Judge Tom Sawaya. To my left, Judge Wendy Berger. We only have one case on the docket this morning, and I suspect that no one has any kind of electronic devices that would interrupt that oral argument. I'm trying to get to my docket. I can't get this open. 15. Yeah, I can't get it open. The one case is Baptiste versus Southeastern Conference Seventh-day Adventists. It's a civil case, so you each get 20 minutes. I have a default at 5 minutes for rebuttal. If you'd like something different than the 5-minute rebuttal time, just let me know and I'll be glad to accommodate you. So whenever you're ready.
Your Honor, the 5 minutes is fine. I appreciate that.
All right, great. Let me reset you. All right, go ahead.
Good morning. May it please the court. My name is Chad Barr, and I represent the appellants in this case. We're here today asking this court to reverse the trial court's final judgment in favor of the appellees and reverse this matter and remand this matter to the trial court with instructions to either enter a new trial or dismiss this matter for lack of subject matter jurisdiction. We've raised 3 issues in our brief, Your Honor. We've raised the trial court's denial of the continuance in this case. We've raised an issue with the weight of the evidence in this case. And we also have raised an issue with the subject matter jurisdiction of the trial court based on the ecclesiastical abstention doctrine. The first issue I'd like to start with is the trial court's denial of the motion for continuance.
Let me ask you this with regard to the continuance. How many times had a continuance been requested?
There were 5 motions that were filed, but only an order was ever entered on one, and that was the one that Ms. Augustine filed when she asked for the continuance based on the health of her mother. So there were 2 filed early in the case by the first attorney, and those were never ruled on. And then there was another one filed by Ms. Augustine. That one was ruled on based on the health of her mother. And then Attorney Lewis, when he stepped into the case, the first motion he filed was procedurally incorrect because it wasn't signed by his client, so we filed another one that was signed by his client. So technically there were 5 motions filed, but only one was ever granted by the trial court.
But this case had been ongoing for years, right? 5 or 6 years?
It has, and I'm actually glad that you asked that question because I was looking at the docket last night preparing for our argument, and one thing I noticed was their argument about prejudice was that this case was filed in 2010, we wanted to go to trial in 2015. If you look at the docket, there were 2 periods of time where the plaintiff in this case went more than a year without doing anything in the case. Nothing was filed. The first time was from 2010 to 2012. A year and a half went by without the plaintiff filing anything. And then there was another time period from 2013 to 2014. Another year went by without the plaintiff filing anything in this case. So for them to say that that's the basis of their prejudice is wholly unsupported.
Well, that really wasn't what I was trying to determine. You know, you've got 5 years, you have at least multiple requests for continuance, one granted. I'm trying to, the burden is quite a high burden that you have to overcome. I mean, it's an abuse of discretion. So we have to say that there's not a judge out there that wouldn't grant a continuance under these set of circumstances. And so, help me out.
I understand that, and I think the issue comes down to this is just a matter of bad luck and bad timing for my clients. The first attorney I mean, he was disbarred during the course of his representation of my clients. The second attorney, her mother fell ill and had a life-threatening illness. And they got a third attorney within the time frame required by the court, but 12 days, 13 days to try a case that is dealing with millions of dollars, 10 defendants.
Of course, but the attorney that was dealing with her mother had been dealing with her mother for quite some time. I mean, that was the impetus for the first continuance, correct?
It was only 3 months. She was only in the case for a matter of months.
Okay, and but she at least filed her motion 5 weeks before trial.
She did file her motion 5 weeks before trial.
So there was, your clients at least at that point knew knew that they needed to get a new attorney, at least at that point.
And they did 12 days later.
Well, 12 days after the judge granted the motion to withdraw, but at the time that the motion was filed, they knew at that time they needed to hire somebody else.
Yes.
And that was 5 weeks before trial.
Yeah, and there's nothing in the record to indicate that they didn't do that. I mean, they were involved, invested in this case from the beginning. Even when their attorney was disbarred the first time, they still were showing up to hearings. They still showed up to the pretrial. When the second attorney withdrew, they showed up to the pretrial themselves and signed the pretrial statement. They did everything they could to make sure that they were involved and invested in this case and represented. It just took them some time to get the second attorney, presumably because they were defendants in a high-dollar case between two church factions, and that's...
Is there any deficiency in the performance of the lawyer that tried the case that you could point to?
No, I think that he did the best he could under the circumstances, but he specifically noted that he was unable to get the documents from the first attorney, and he needed to get an expert to rebut their expert. Their expert filed a report that was hundreds of pages long, and he said, I need to get an expert for my clients. So I think he did the best he could under the circumstances, but he needed more. He needed more time.
How long had it been since your clients knew that they were relying on an expert? I mean, when was their expert disclosed?
Their expert was, their report, Attorney Augustine stated in her motion to continue that she received the report for the first time in April of 2017. Now, that's just before her mother fell ill, and she asked for a continuance because her mother fell ill and because she needed additional time to conduct discovery, but she didn't conduct any discovery during the time her mother was ill.
Nor did she hire an expert, which she had, April, May, June, July, 4 months.
Correct, but that's also during the time that she was dealing with her mother, who was in Georgia, who's facing this life-threatening illness, and I think that's where we get to.
When was the expert disclosed? Not even the report, but when was it disclosed that this individual is going to be used as an expert?
I think, based on my review of the record, it was April 5th, I believe, in the pretrial statement. It's a very voluminous record, and it's actually very choppy as well, which is why we had to file so many supplemental records, so I apologize to the court about that. But I believe it was April 5th of 2015, and then the report, Attorney Augustine said she received the report for the first time on April 27th, 2015, in her motion to continue.
The Supreme Court gives guidelines to trial courts about the time frames for cases to be pending.
I am aware of that. I'm aware of that.
This was way past that.
It was, but in the 5 years that the case was pending, 2.5 years of that time, the plaintiff filed absolutely nothing in the case.
You don't have to wait for the plaintiff to do anything. You could be doing things on your own.
I agree with that, and again, this is nothing that was caused or a...
All right, let's move on to the other issues so that you have time to get into all of your argument. What church doctrine was involved in this case that you cite, for relief?
I think that this case was entirely premised on the local church manual and the national working policy.
That's different than doctrine. You can have contracts, you can have a structure of a church, and that's different than church doctrine, don't you think?
I believe that the beginning of those manuals describe that this is the basis of their doctrine. Those documents are the basis of their doctrine, their religion, their faith. And
is, for instance, the fact that a tithe is to be transferred, I know that there's a whole organization here, but that the tithe goes to either the regional or national organization, not to the local church. Is that church doctrine or is that just structure?
I think it's church doctrine because the underlying issue in this case was an interchurch dispute. My clients wanted to build a community center to reach the community, and they felt they were being stonewalled by the plaintiffs in this case. So they had an intra-church conflict, and they took a church vote, this is all in the trial testimony, to withhold the tithes so that they could resolve whatever dispute that they were going through. So how the church governs those inter-church conflicts is based on...
Your people at the time of trial weren't in the church anymore, right? They had withdrawn and formed their own church.
I don't know if they had formed their own church, but I knew that they had withdrawn from membership.
And they set up their own corporation, correct?
I believe so. Unrelated to this.
I'm struggling with the church doctrine and what religious doctrine as opposed to structural, there's governance in every organization, whether it's a religious organization, a civic organization. I mean, this almost, I don't mean this as an analogy, as a direct analogy, but almost like a franchise, where you get a franchise and there are rules and regulations, and you have to send records, and you have to have a percentage of the profits, and so you have a structure of the franchise and the franchisee. Is that I'm just trying to understand that as a religious doctrine, as opposed to simply the hierarchy, the structure of the church.
Right, and I think that what we have to look for is there a neutral principle of law, and I don't think that outside of the way that the church governs itself, the way the church handles inner conflict, the way that the church...
Under that theory, you would never have any case that could go into the court system, and that's not the law.
Well, with respect to religious institutions, there has to be a neutral principle of law that allows the court to step into that entity and make decisions.
And as a property dispute, why doesn't that qualify?
Well, it's easy to classify it as a property dispute, but the underpinnings of this case are an interchurch conflict and the way that is resolved.
The underpinnings of this case are that the church believes that there was money that belonged to it that was taken from it by these other individuals. And the church property, and then the money and the tithes and the contributions that belonged to the church were taken and appropriated. I mean, that's the property dispute. I mean, I fail to see the doctrine that's involved.
You have to look at
whether you owe me money or you don't.
You have to look at what the basis of the claims are. We've got fraud. We've got breach of fiduciary duty. The entire basis of the fiduciary duty claim is set forth in the church doctrine, the church documents that they're relying on. The fraud claim.
The client testified that he owed the church a fiduciary duty.
He owed the local church a fiduciary, Gilgal local church, fiduciary duty. He did not testify that he owed the Southeastern Conference a fiduciary duty. But their claim of fiduciary duty comes from the church manual and the church policies. That's the basis of their fiduciary duty
Just
claim.
policies or just policies in terms of finance?
I'm sorry, say that again.
Religious policies or policies of finance, that this is how the finances of the church will be set up. We've got the global, we've got the national, we've got the Southeastern Conference, and here's how money is going to flow between these organizations.
That is part of it. That is part of that process.
Isn't that the crux of the lawsuit, is how are funds collected by a local church dispersed? Who are they dispersed to? Who has a right to keep them? Isn't that what the basic premise of this lawsuit's about?
No, I think the premise of the lawsuit is that their allegations are that my clients breached the fiduciary duty. The fiduciary duty comes from the manual and the policy. They committed fraud. In their brief, they say the fraud that they committed was that they said they were going to obey the policy and act according to the policy and the manual, and they didn't. That's the only basis. That's the misstatement of fraud. It's based on the policy.
Everything in the manual doctrine?
I believe that,
Is that your argument, is that if it's in the manual, it becomes part of church doctrine?
I believe the manual and the policy state that this sets forth our doctrine and our religion. I believe that the manuals state that. And I believe I've cited to that in my brief, and I can find that for you and reference that on my rebuttal argument. But I believe that the manuals make it very clear that this defines our religion and defines our faith. And it's based on whatever religious document that they believe in to support those positions in the manual and the policy. So it all comes from that. It's defining how they act within the religion right there in the policy and manual.
Now, is your position that the undercurrent to this lawsuit is about how the Seventh-day Adventists treat Haitian churches?
I believe that was the underpinning of the dispute, the original dispute. Yes, that's what was testified to by my clients at trial, was that they felt that they were being treated differently than other churches because they were a Haitian church.
And was there other evidence of the unfair treatment of Haitian churches presented at trial?
I don't believe so. I don't believe that there was any other evidence other than their testimony that they believe they were being treated unfairly. The last thing I'd like to just touch on briefly, Your Honor, is the evidence in this case. I've laid out in my brief why I don't believe that they've met the elements of each of their cause of action, but what I want to do is I just want to spend a few minutes of my time. What I've done is I've identified about $2.2 million of the $2.5 million judgment that there's absolutely no evidentiary support for. The first, and these are all things that were included in the line-by-line items that the trial court based its $2.5 million judgment on.
She based that judgment on the testimony of their expert and the documentation that the expert, that they admitted into evidence, correct? It went into evidence without objection.
Yes, but the final judgment and the line items don't correlate with what's actually being said in those documents. And I'd like to just give you a couple of examples. There's $36,000 that went to Miss Charles, and she testified that was pay for her. That was actually payroll. And Miss Gavrich, the expert, said, "I'm accounting this to her as payroll," but that was still included in the $2.5 million judgment. There were deposits to the community center account. There's multiple accounts. There's a community center account of $212,000. There was no testimony whatsoever that my clients took any of that $212,000. It was not taken by my clients when they left the church, but it was included in the final judgment. Moreover, there was no testimony that it was not accessible to the appellees. There was a $68,000 cash out of a life insurance policy. Ms. Gavrich testified that there was a $68,000 deposit made to one of the community center accounts. And again, that money did not leave. It did not go with my clients when they left the church. There's no evidence that it wasn't accessible to the appellee. The most important one is there's $1.7 million worth of tithes and offerings that Ms. Gavrich accounted to my clients during a time period in which the appellee's corporate representative testified that my clients were paying tithes and offerings to the SEC. So she took this, Ms. Gavrich basically accounted for all the tithes and offerings received for an entire period of time, but during that period of time, my clients were paying, and their corporate representative testified, my clients were paying that money to the SEC. $1.7 million, but that was included in the final judgment. Ms. Gavrich did not testify that money did not go to her clients. She just said, this is the money that was collected. Their client, or their corporate rep testified they received money during that time period. There was a $20,000 payment to another.
Did they testify to the amount received, or that they received money? Was there
She said that she said the only time that we didn't receive money was from July 2006 through December of 2008. But Ms. Gavrich included in her accounting all the money that the church received. I actually don't represent the church, but the church received from January 2005 to June of 2006. So a year and a half period of time that my client was paying was included in Ms. Gavrich's total calculation, and this is all laid out in the brief. So we've got $1.7 million right there. We've got a $20,000 payment to another Seventh-day Adventist Church that was repaid. Ms. Gavridge testified that that money was repaid, $20,000, but it was included in the final judgment. Cash withdrawals of $22,000. There's no testimony evidence whatsoever that that money went to my clients, that my clients benefited from that money whatsoever, $22,300. And then the last one is $90,000 worth of verified payments made by J&R Enterprises back to the church, $90,000. Ms. Gavridge testified that there was an account with a debit and an account with a deposit of $90,000 to Gilgal, $90,000 that was counted towards my clients in the final judgment. And these are just examples. I've laid out the rest of them in my brief, $2.5 million, and I've identified $2.2 million for which there's no evidence whatsoever that that money should have been counted against my clients. At the end of the day, aside from the loans, which may be in dispute, whether they were repaid or not, the money that was left in the accounts at Gilgal and at Gilgal Community Center were not taken by my clients. There's no evidence whatsoever that they were taken by my clients and that those monies were not available to Gilgal or the SEC at the time they left the church.
I just have one question. It's regarding the ecclesiastical doctrine. It looks to me like these are property disputes. If these property disputes do not fall within the jurisdiction of the Florida courts to resolve, how are they going to get resolved?
I don't know that I have an answer for you other than it's a matter of interchurch conflict that the United States Supreme Court, in my opinion, has held that matter.
It would be a matter of some tribunal set up by the church to resolve these issues, and the church is a party to the dispute, and they're the ones that are going to resolve it. I mean, how does it get resolved? I think
that's how it's normally done, and whenever you have, I think that's what's normally done whenever you have a religious organization, is they have some tribunal set up or some way to deal with those conflicts, and I don't think that the courts are the way to do it. I'll reserve the rest of my time. Thank you, Your Honors.
Well, actually, you have no other time. I'll give you a couple minutes.
Okay, I apologize.
Extra, and so I'll give you some extra time as well. I'm going to put a few extra minutes of time for you, so I'm going to allow him a few minutes for rebuttal.
Thank you, Your Honors. Good morning, and may it please the court. I would like to introduce counsel and our client who are in the courtroom. I'm Nicolette Vilmos, and to my right, I have Linda Spalding White from Broad & Cassell, and Jim Kazar from the Bricewell Law Firm, who is counsel to the conference as well as co-counsel in this case. As well, I have two of the three officers of the conference, Gregory Mack, who is currently the president of the conference, and Michael Owusu, who is the executive secretary. Your Honors, I will be addressing the appellant's argument related to the sufficiency of the evidence, and we have segregated the argument.
Let's start at where he finished with these various items that he thinks were improperly included in the final judgment.
Yes, Your Honor. Your Honor, Judge Berger, you questioned or made a statement that the judgment was based upon the expert report that was admitted without objection, and one of the responses that counsel made was he set an example regarding the transfers to Jeannine Charles, who was the employee, and there was testimony that she received employment checks, and those were counted improperly, and there was not a credit given. We have all of this laid out in a brief, but I would point the court to the record, which is not only the expert report, but also Ms. Gavridge's testimony, where she testified that, quoted, although we initially identified payments for plaintiff to Jeannine Charles that totaled $44,344, I decreased this amount to $36,804 to count for any payments in the amount of $2,500 for wages. So specifically to that issue, although the appellants made the statement that there was no credit, there was a credit. And Ms. Counsel also made a comment that there was not a credit with the accounts that remained, because when his clients left the church, all those counts remained at the church. I'll address that in two ways. First, there was only one account that was authorized to be opened by the conference that the conference had access to, and those amounts were not included in the judgment. All of the other counts were opened by the defendants. In the defendants' names, we had no signatory rights, and if you look at the report, we have no idea, even to this day, where they are. We didn't have access, so there was no evidence presented that those monies stayed with the church. We don't know what happened with them. We assume that they were used for the defendant's benefit because that was the only evidence that was presented at trial. Additionally, counsel indicated that tithes were not credited that were sent up to the conference. And in the record at 7479, the expert specifically indicated that she credited all the tithes to the account that went up to the conference. And so everything that the expert could identify, even by the date where tithes and contributions, if she could distinguish the separation, she gave the defendants the benefit of the doubt and credited those as tithes and made the assumption that they were used for legitimate purposes at the local church. They raise a lot of issues. There were a lot of different transfers. So generally, I will say with regard to all of the accounts that were opened without the knowledge or the authority of the conference, the assumption was made that once a penny or a dollar hit that account, it was included in the amount of the judgment because it was not used for the conference benefit and it was not used for the church's benefit because the church did not, or the defendants did not present any evidence or testimony that it was used for operational expenses, it was used to keep the lights on. They had access, they had control of all those documents, they had the requirement to keep documents and produce them, and the testimony was that there was an alleged break-in and all the documents were stolen except for blank checks, which apparently remained at the church. Those were not stolen, but all of the financial records and backup disappeared. And that was when the church was under their control. But it was their burden to show that those tithes or the money in those accounts were used for legitimate purposes, and there was no evidence of that.
Is the structure of where tithes go part of the doctrine of the church?
Your Honor, I'm going to answer that because it does cross over. Ms. Spalding-White is going to address the subject matter jurisdiction as well as the continuance, but it does overlap, and I had been prepared to answer that question. The working policy, which is at specifically record 1413 and 1414, under the organizational and operational principles of the Seventh-day Adventist Church, Judge Cohen, you had specifically alluded or indicated that the governance is like an organization such as a franchise, and it specifically contemplates that in here. The working policy says, the church manual and the general conference working policy present the collective voice of the Seventh-day Adventist regarding beliefs, denominational structure, relationships, and operational procedures. And specifically the tithes and the offerings and any other collections are part of the operational structure of the church. And there is governance in both of these documents. You could just look through the index and see that there are operational procedures just as any other company or corporation, and that would be covered under the operational component of those policies.
I don't think that there's overlap between doctrine and structure?
They're not as far as it's concerned from the financial component. There are beliefs that are part of the religion that talk about how much this faith believes tithing should be, the percentage, et cetera. But as far as how the church is supposed to operate and keep the lights on and establish itself as a global, worldwide establishment, that is operational and is not covered by doctrine. If Your Honors don't have any other questions as to the evidence, I would turn it over to my colleague, Ms. Spalding-White.
Okay.
Thank you.
Counsel, since you brought all of that material with you, could you read that big one to us?
I don't think she heard you.
He's joking.
He's joking.
Okay.
Moment of levity.
May it please the court, good morning. Linda Spalding-White. Let me go back to the church doctrine, since that's where we left off. The church doctrine is not involved here based on the personal property claims that have been asserted based on the tortious conduct. Church doctrine has to do with the religious beliefs. The church polity governance has to do with the ministerial structure. What we're dealing with here is how their church elders, their church officers, church board members of the conference. It's how they are supposed to handle the financial workings, who owns the tithes, who owns the offerings, what they're supposed to do with them. Religious belief has no play into how they're supposed to operate.
How about the underlying current that the church was treating Haitian churches differently than other churches? Would that be structure, or would that be doctrinal, a function of doctrine?
The Haitian culture that they raised at trial is a secular issue. It is not a religious issue. And even the church manual and the working policy talks about the fact that it is a worldwide church with many cultures. But the fact that they are Haitian culture does not give them the right to either ignore or to modify the organizational obligations, the financial procedures within the church. They did not own the tithes. They were obligated to strictly adhere to the working policy. And they were told that they could not use any of these funds. They were held in trust for the conference, that they could not use, they could not borrow, let alone lend these funds for any purpose.
Including capital,
They had to seek approval for any building projects that were in excess of $6 million, which the project that they were, that Pastor Baptiste was trying to promote would have been governed by, and would have, they had to seek approval, and there is correspondence. They never actually sought the approval for that project.
He had grown this church significantly, had he not?
They had. They had grown the church significantly. But the bottom line here is culture did not, that's not a religious belief, first of all. And if they felt they were discriminated against, it still did not give them the right under the express dictates of the manual.
Would that be something that the church would handle internally if there were issues of allegations of disparate treatment between the Haitian sections of the Seventh-day Adventist movement?
There are provisions for conciliatory and settlement regarding grievances between members, between grievances between the church and members, but these are grievances more of a religious nature, or if they were going to be disenfranchised or kicked out. Their procedures don't deal with this type of claim. They don't have a judiciary like some of the other hierarchical churches. They didn't have a process to deal with this. They did not have the ability to force these former fiduciaries to return the money or to obtain a judgment. The only way for them to seek relief for the money that was misappropriated, converted, whatever you want to call it, stolen, was to file a civil action, because they don't have a mechanism for that within the operating policy or the manual. This was the only avenue. And quite honestly, especially in a real property situation, they don't have a right to force someone to transfer property.
Is this a collectible judgment?
That's a good question, and that also ties into the 67-month delay in trying to get this to trial, is the money that probably they could have tried to collect may be gone now.
Were there periods of time, as outlined by appellant counsel, that the trial judges, or I'm not the judges, but the lawyers for the church effectively didn't do anything?
What do you mean that they didn't?
He outlined.
Oh, you mean as it relates to the continuance?
Right.
The way, not really, Your Honor. The pleadings were closed. The conference had engaged in discovery, and as set forth in the brief, the appellants failed to respond. You have to remember here, they held the documents because they were the ones that had all of the financial records, all the books and records that actually our client needed to be able to prove the transfers. It was within their records that allegedly were stolen at some point between when before the action was filed. Of course, no police report was made. But they're the ones that held the records. And we had to file many motions to compel. There were numerous orders to show cause. We couldn't get the records from them to be able to move forward with the case. And when it was finally set for trial, when they had their first lawyer, and that was set for trial more than a year before the trial setting. And their attorney did withdraw, and it was 9 months, and they took no action to retain counsel for 9 months. And then they were getting ready for trial, and their first attorney withdrew 1 month before the first trial, and the second attorney came in, Ms. Augustin, and she sought a continuance. She filed 3 motions, one of which was non-compliant and denied. The second one was actually rendered moot when the court granted her emergency motion to continue for a month based on the ill health of her mother. There were time lapses, but it was more due to the fact that our clients couldn't obtain the documents and had to continually move to compel, move for orders to show cause to try to get the records.
Now, this case was moved to the complex business litigation court, correct?
Yes.
At the request of the conference?
Yes.
And then it's transferred there, and then their attorney withdraws, and the new attorney has 2 weeks to get prepared for a complex business case, and you think that's enough time for a new attorney to get ready for a case such as this?
That's not really how it occurred, though. So why don't we back up and we'll get the procedure straight. The second attorney filed her motion 5 weeks before the trial setting, before the original trial court. And the appellants did nothing to retain counsel. and they knew that she wasn't going to be able to try the case. And when she filed her motion, she didn't seek a continuance. You know, a lot of times when an attorney will withdraw and they know the trial is coming up, they'll also ask for a continuance. That didn't occur. And then when they finally had the hearing on her motion, where the appellants attended with her, it was also the pretrial conference, and they went through the pretrial conference, and at the end, they allowed her to withdraw. They knew the trial at this point was a few weeks away. They did not ask for a continuance. They didn't ask for a continuance so they could retain new counsel. They even filed their pretrial statement, and they did not retain counsel until about 2 weeks before the trial. And immediately when they appeared, they moved to recuse the judge. Honestly, I think when they thought they moved to recuse the judge, that was going to buy them the continuance. The judge did recuse himself, and at that point is when, so he was already in the case, already moved to recuse. That's at the point when we moved to transfer the case to the complex litigation, because it qualified. It was seeking the amount that it needed to seek. It had the number of parties and the claims.
Let me ask you this. When
And
did
they objected to it being transferred. So to me, they objected to the transfer, which you could infer that they felt that it wasn't complex.
Let me ask you this. When it came to trial, the date of trial,
Yes, Your Honor.
did defense counsel on the date of trial ask for a continuance at that point? Was any,
No, he didn't, Your Honor. And I went through, and that's why we kept trying to get the full transcript and wanted a complete record before the panel. He did not request a continuance. He acknowledged that they had received all the documents. I mean, it was his client's documents, anyway, that we had to get from the different banks and whatnot.
so there was no indication on the date of trial, Your Honor, this is a complex case, I've just received the documents, I'm not going to be adequately prepared to try this case, I renew my objection, I renew my request for continuance, none of that.
There was no renewal of the continuance at any point in the trial. The only thing that counsel did ask is if there was some document that he hadn't seen, that he would have an opportunity to review it before it was given to the witness, and the court granted that. And you know, I want to go back and answer a question. There was no allegation here that prior attorneys had not adequately prepared the case, because one of the decisions addressed that. That was not present here. And quite honestly, if you really look at the motion to continue, the second one that was filed by Mr. Silver, is that they wanted to be able to have an expert accountant review the expert report. If you go back and look at the motion, they weren't seeking to list an expert witness.
That's preliminary. I'm not terribly impressed by that argument, but nor on the argument that because they objected to its transfer that they don't think it's a complex case. That doesn't resonate with me either. Let me ask this: this pastor takes this small church from 75 people to 1,000 people, which is quite a job, and so he wants a bigger facility. And so they start a fundraising campaign, and certainly the SEC had to be aware that they were fundraising and didn't apparently do anything to stop that. And they get all the way to a groundbreaking ceremony that the SEC owns the property. How can it go that far, and go along that far in the process? And SEC had taken no steps to intervene at that point.
That's probably a good question. There was correspondence back and forth. They had started the process.
You're not sure whether it's a good question or not. I'm just trying to. Neither am I.
I'm not sure why they had not intervened, but I don't know that that is really the question here. At trial, the defendants had the opportunity to come in and say, we did this properly, these are the funds.
If you want to.
Okay.
Yeah, I'll let you, yeah. We happen to have
Do you
some
have any more
time,
questions
so
on the
we'll-
continuance?
Pardon me?
Any more questions on the continuance?
Go ahead, you can address
Judge
that.
Cohen, to answer your question, the church did intervene, and that is in the record, starting at 7421, and there's a series of correspondence that goes from the conference to Pastor Baptiste or Antoine Alexander, acknowledging that I know you want to have this project, however, you have not received the executive committee vote, and you need to follow the proper channels. The conference was attempting to work with them to actually go forward with this. What we didn't know what was happening in the background was that they had opened these accounts and they were going along without our knowledge.
Okay, all right, thank you. All right, rebuttal. I'm going to go ahead, yeah, I'm just going to turn this, I'm going to give you a couple minutes of
Did you-
time. So let me,
I'm sorry, how much time, Judge?
I'll give you 3 minutes.
Okay.
Let me see if I can.
We're both
just
very
go-
passionate
Yeah,
about
just
this
go ahead,
case, so-
and I'll let you know when you're done, okay?
Okay.
With regard to the continuance, you got it started?
Yeah, no, go ahead, I'm just going to do it.
With regard to the continuance, is she correct, or am I correct in not reading that there was no request renewed for the continuance at the time of trial?
There wasn't, Judge, but you know, I can't substitute myself in as an appellate attorney knowing every in and out. That's a good idea. It's certainly not required. There's no second request that has to be made. The request was made. It was based on the health of the prior attorney's mother. I think that the case law that we cited in our brief clearly shows that the standard is not the mountain high standard that the appellee made it in its brief. If there's
How many cases can you cite to us where trial courts get reversed for failing to give a continuance? I mean, it's a very small number of cases. It is a high burden, because the standard is an abuse of discretion standard, and you're an appellate lawyer. You know that that's a difficult standard for a litigant to meet.
We actually cited 4 or 5 cases in our brief where the courts were reversed because of the continuance was based on the health of either the attorney's spouse, or the client. And in this case, our position is without the second attorney withdrawing due to the health of her mother, we wouldn't be in this situation. You know, all indications were that she would be ready to go. There was nothing to indicate that she wouldn't be. Her emergency request for a continuance was because of her mother's health. And that's where we were at that point in
But
time.
that's
She got
granted.
that she got that continuance.
And she did, but she had to withdraw, days later, just virtually days later. So if it wasn't for that, we probably wouldn't be in this situation. So I think that based on that fact, that was the triggering event. Her mother's health was a triggering event for Attorney Lewis stepping in and needing additional time.
Well, when was that continuance made, that initial request for continuance? What date was that?
That was made on. I have my notes over there. I apologize, but it was made just a number of days after I think he entered an appearance on the 13th, and the request was made within a week. August 26th. August 26th. The day it was transferred to Complex Business Court was the day that the request was
Yeah,
made.
but when was the initial request from Ms. Augustin for a continuance? When did she initially get the continuance?
July 16th.
Okay, and so
Or
then,
July 25th. Within 3 weeks of her making the request, they had a new attorney.
well, July, that's when she moved to withdraw. When did she initially request the continuance for her mother? The first continuance that was
Can I
granted?
grab my notes?
Sure, go ahead.
Thanks. July 20, May 3rd.
So May 30th, she asked for the continuance.
May 3rd, May 3.
May 3, okay, and so then you said just a moment ago that within days after she asked for that continuance.
I thought you were asking me how long it took them to get another attorney after she withdrew. I thought that's
Okay,
the day she
that
filed.
was like 13 days,
Right.
but,
The
okay,
health of her mother was raised on May 3rd. She withdrew on July 25th.
okay.
So initially, her request was because her mother was found unconscious. She needed to go deal with her. It then progressed to the point where her mother was now in a coma. That was kind of the progression of things. So it wasn't like we knew right away that she had a serious life-threatening illness. At first, it was a fall, I believe, and then it progressed to a life-threatening illness, and that's when she moved to withdrawal in July. I wanted to point out, because I think it's significant, the court can take it for what it's worth, but you asked her about the amount of time that there was no activity, and I want to make sure that those dates are clear. From August 6, 2010 to February 9, 2012, nothing was filed. There was no filings in this case. From February 4th, 2013 to February 10, 2014, there were no filings in this case. Nothing was filed in this case. So 2.5 years of a 5-year docket, the plaintiff did absolutely nothing in this case.
Oh, but the fact that there were no filings doesn't mean that there weren't things going on.
Well, that goes to the only thing they pointed to in their brief, and they tried to sneak in the thing about whether the judgment was collectible as part of the prejudice, but they didn't put that in the brief. The only thing they said in the brief was prejudice was, we're entitled to get our trial. Well, yeah, you're entitled to get your trial, but you can't say that everything was due to our client. It was half of that time, nothing was filed. So they weren't pushing this case along. And I wanted to just point out
But do you agree that the records of these financial transactions were within your client's control?
some of them, again, I don't represent the church. I represent just 4 of the officers of the church and 1 corporation. But some of the documents would have been, but I can't speak for what specifically they had control of and what they didn't.
So having control of those documents, you know, if they wanted to secure a forensic accountant, that would have been, you know, something that was very doable for them.
I certainly suppose, but they were really hampered by the first 2 attorneys that they had, and.
All right. Well, your time is up on this.
Okay. Thank you, Your Honors.
Thank you all for the argument. We'll be in recess.